What you're about to hear sounds impossible. Within the span of just 2 days, one of America's most recognizable business empires watched its entire legal defense system fall apart. Not gradually, but spectacularly. We're witnessing a moment where a judge didn't just dismiss arguments, she eviscerated them, using words like without merit, procedurally improper, and frivolous to describe the legal strategy of someone who once occupied the highest office in the nation. But here's the part that should keep you watching. The machinery of asset seizure isn't waiting in the wings anymore. It's already moving. Iconic properties that have loomed over Manhattan's skyline for generations are now being targeted for seizure. The question isn't whether this will happen. It's how we arrived at this extraordinary crossroads, why every emergency legal maneuver collapsed like a house of cards, and what it reveals when the courts, financial institutions, and bond underwriters all reach the same conclusion simultaneously. This isn't a story about politics. It's a story about whether the law still applies equally when billions of dollars and decades of influence are on the line. The judgment that changed everything. Let's establish the facts, because the sequence of events here reveals everything you need to understand. Several weeks ago, a New York judge delivered a final ruling against Donald Trump following an extensive civil fraud trial. The decision was unambiguous. Trump and his organization had engaged in systematic, long-term fraud over more than 10 years. The financial penalty imposed wasn't a negotiable fine or a settlement figure that lawyers could whittle down through backroom deals. This was a disgorgement order, a legal mechanism that forces defendants to return profits they earned through illegal activity. The amount, $454 million. Trump's attorneys did what any defense team would do. They immediately filed emergency motions asking the court to halt enforcement while they pursued their appeals. This is standard operating procedure in American civil litigation. Defendants have the right to challenge adverse judgments through the appellate process, and courts routinely grant temporary stays to prevent irreversible harm while those appeals play out. But what happened next was anything but routine. Within a matter of days, those emergency requests were denied, not with the polite, carefully worded language courts typically use, but with a level of judicial bluntness that stunned legal observers across the country. The appellate judge assigned to review Trump's emergency motions didn't simply decline to grant relief. She methodically dismantled each argument his legal team presented, concluding that they were procedurally defective and completely lacking in legal substance. Pay attention to this detail because it matters. Judges, especially at the appellate level, are trained to use measured, neutral language even when they fundamentally disagree with the arguments before them. They avoid inflammatory rhetoric because it can create the appearance of bias and provide grounds for further appeals. When an appellate judge breaks from that norm and uses unusually harsh language, it's sending a signal, not just to the parties in the case, but to the broader legal community. The three arguments that failed. Now let's examine what Trump's lawyers actually argued, because understanding their strategy reveals why it failed so completely. They advanced three primary contentions. First, they claimed that forcing Trump to satisfy the judgment before his appeals were resolved violated his constitutional right to due process, the fundamental principle that no one should be deprived of property without fair legal process. Second, they argued that requiring a bond exceeding $400 million was impossibly burdensome and appeared designed specifically to destroy Trump financially. Third, they asserted that the entire prosecution was politically motivated, a case of the New York Attorney General weaponizing the legal system against a political opponent. The court's response was devastating. Rather than engaging with these arguments on their merits, the judge essentially indicated that they ignored foundational principles of New York civil procedure, rules that apply uniformly to every defendant, regardless of their wealth, fame, or political connections. 30 rejections. The market speaks. But the most revealing moment came buried in the court filings, in details that most news coverage glossed over or missed entirely. Trump's legal team disclosed that they had approached more than 30 separate surety bond companies, financial institutions whose core business model centers on assessing risk and providing bonds for civil defendants facing judgments. These aren't small regional firms. These are sophisticated financial entities that regularly underwrite bonds worth tens or hundreds of millions of dollars. Every single one refused to provide Trump with a bond, not because of political pressure, not because of negative media coverage, but because, after conducting their independent due diligence, examining Trump's assets, reviewing the fraud judgment against him, and running their risk assessment models, they each concluded that backing Trump represented an unacceptable financial risk. Let that sink in for a moment. These are companies that make money by taking calculated risks on defendants in exactly Trump's position. They assess massive bond requests routinely. And across the board, after professional analysis, they said no. When a defendant applies for a large surety bond, these companies launch exhaustive due diligence investigations. They examine every asset the defendant claims to own. They verify ownership structures through corporate records and property registries. They review all existing liens, mortgages, and debts attached to those assets. Most critically, they conduct completely independent valuations. They don't just accept the defendant's assertion about what something is worth. They hire their own professional appraisers, their own forensic accountants, their own legal specialists. In Trump's case, more than 30 companies went through this exact process independently. And every single one reached the same conclusion. The risk of loss was too high to justify issuing the bond. This wasn't a coordinated conspiracy. This was the market, that invisible hand economists talk about, rendering a verdict based on financial reality. The implications of this rejection extend far beyond Trump's immediate legal predicament. Without posting the required bond, New York's civil procedure laws are, crystal clear about what happens next. The Attorney General's office gains the authority to begin enforcement immediately. That means they can identify specific assets, file legal claims against those properties, and, initiate the process of actual seizure. According to sources with knowledge of the proceedings, the Attorney General's office has already compiled a detailed inventory of Trump-owned properties throughout New York State. The list includes some of the most prominent addresses in Manhattan 40 Wall Street, a historic skyscraper in the financial district, Trump Tower on Fifth Avenue, perhaps the most publicly associated property with the Trump brand, and several other significant commercial real estate holdings. When you add up the estimated values, and here's where it gets complicated, you're looking at somewhere between $600 million and $1.2 billion, depending entirely on whose valuation methodology you trust. Which brings us to the bitter irony at the heart of this entire situation. Trump was found civilly liable for fraud, specifically because he systematically inflated the stated values of these exact properties when dealing with banks, insurance companies, and financial partners over many years. His organization would claim a property was worth one figure when seeking favorable loan terms, then claim a dramatically different figure when calculating tax obligations. So when Trump's attorneys now stand before the court arguing that these same properties are worth enough to cover the judgment and should therefore be protected from seizure, the court's response is almost inevitable. We literally just ruled, after reviewing mountains of evidence, that you've been lying about these valuations for over a decade. Why would we simply accept your word now? The judge's ruling addressed this point with surgical precision. She noted that Trump had been found liable for fraud specifically because he habitually and systematically overstated the values of his assets. During the trial itself, Trump's own expert witnesses had admitted under cross-examination that his financial statements contained inflated figures. The court had reviewed thousands upon thousands of pages of documentation showing a consistent pattern of valuation manipulation spanning many years. This isn't political persecution. This is what happens when the gap between what someone claims assets are worth and what the market will actually support becomes undeniable, documented, and public. Let's dig into the actual legal architecture here, because this is where, honestly, most mainstream analysis completely misses the deeper significance. The bond requirement that Trump's team is fighting isn't some arbitrary weapon that courts wield against defendants they don't like. It serves a specific critical function in the civil justice system, one that balances competing interests in a way that's absolutely essential to making judgments meaningful. Here's the problem the bond requirement solves. Without it, defendants facing large civil judgments could spend years navigating the appeals process while quietly reorganizing their financial lives. They could transfer properties into shell corporations registered in foreign jurisdictions. They could restructure ownership into family members' names. They could move liquid assets offshore into banks that don't cooperate with U.S. legal orders. By the time all appeals are finally exhausted, which can take 5, 7, even 10 years, there's literally nothing left to collect. The judgment becomes a piece of paper with no practical value. The bond requirement prevents exactly this scenario. It ensures that if your appeal ultimately fails, the money will still be available to satisfy what you owe. New York's appellate rules spell this out explicitly. If you want an automatic stay preventing enforcement while your appeal proceeds, you must post a bond equal to 110% of the judgment amount. In Trump's case, that calculation produced a figure of approximately $500 million. His legal team immediately attacked this requirement as excessive, unconstitutional, and specifically designed to target him for political reasons. But here's the data that completely undermines that argument. New York courts grant stays with reduced bonds or without bonds at all in only 2 narrowly defined circumstances. First, when a defendant can demonstrate they genuinely lack the financial resources to secure a bond at the required amount. Second, when there's compelling evidence that the underlying judgment was based on a fundamental legal error so serious that it's almost certain to be overturned on appeal. Trump's lawyers attempted to argue both. But here's where they ran into an impossible contradiction. They claimed Trump couldn't possibly secure a bond of that magnitude while simultaneously insisting that his property portfolio was worth far more than the judgment amount. You can't have it both ways. Either you have substantial assets, in which case you should be able to use those assets to secure a bond, or you don't have substantial assets, in which case your claim that enforcement would cause irreparable harm loses credibility. The court spotted this logical impossibility immediately. Let's address the constitutional argument, because this is where the legal analysis gets, genuinely fascinating. Trump's team argued that enforcing a judgment before appeals are complete violates due process protections under both the U.S. Constitution and New York's state constitution. On the surface, this sounds compelling. How can the government take someone's property before they've had every opportunity to challenge the legal basis for doing so? But here's what that argument deliberately obscures. Due process doesn't mean infinite delay or consequence-free litigation. It means you receive proper notice of the charges against you. It means you get a fair opportunity to defend yourself in court. It means you have the right to present evidence, cross-examine witnesses, and make legal arguments. It means you have access to the appeals process to challenge errors. Donald Trump received all of that. The original trial lasted for months. Trump's attorneys cross-examined every prosecution witness. They presented their own expert witnesses. They made every legal argument they wanted to make. The judge issued a detailed ruling stretching more than 100 pages, methodically explaining the factual findings and legal conclusions that led to Trump's loss. That is due process in action. The bond requirement doesn't undermine due process. It protects it. Think about this from the other side of the equation. If defendants could automatically delay enforcement for years simply by filing appeals, what happens to plaintiffs? Or in this case, the state seeking to recover illegally obtained profits? They wait years with no guarantee they'll ever collect a dollar. Meanwhile, the defendant has every incentive and opportunity to hide assets, restructure ownership, and shield wealth from collection. The court made a point that should be obvious, but apparently needed to be stated explicitly. The bond requirement has been upheld repeatedly by New York's highest courts over many decades. It applies uniformly to every civil defendant who loses a money judgment and wants to appeal. Corporate executives facing securities fraud judgments, small business owners who lose contract disputes, real estate developers found liable for construction defects. Everyone. Trump wasn't being singled out for harsher treatment. He was being held to exactly the same standard as every other defendant in his position. The only difference was the size of the judgment, which directly reflected the scale and duration of the fraud the court had found. So what does all of this actually mean beyond courtrooms and legal arguments? Let's trace the ripple effects, because they're already spreading in ways that, honestly, most coverage isn't even tracking. Start with the employees who work in Trump-owned properties. Take 40 Wall Street as just one example. That single building directly employs hundreds of people: building maintenance workers, security personnel, administrative staff, property management professionals. If that property is seized by the state and sold to satisfy the judgment, what happens to those jobs? We're talking about security guards who've worked that building for like 20 years, administrative assistants supporting families on their salaries, maintenance crews with specialized skills who've built their careers around that property. These aren't abstractions or statistics. These are people whose mortgage payments, car loans, and children's college funds depend on the stability of their employment. Now consider the small businesses operating as tenants inside Trump properties. Restaurants, law firms, financial services companies, retail shops. Many of these businesses signed long-term commercial leases with specific terms they negotiated with Trump Organization representatives. If ownership changes hands through a forced sale, those lease agreements don't simply disappear, but they become deeply uncertain. Zoom out further to the broader New York commercial real estate market. If multiple major Trump properties hit the market simultaneously through forced sales, that represents a massive supply shock in an environment that's already facing some serious challenges. Commercial real estate in Manhattan has been struggling ever since the pandemic fundamentally reshaped how companies think about office space. Dumping several major commercial properties into this market at once could depress prices broadly, affecting every commercial property owner in the city. That means pension funds holding real estate assets in their portfolios take losses. It means banks holding commercial mortgages see their collateral values decline. It means property tax revenues for New York City could decrease, which affects funding for public services and infrastructure. Former federal prosecutors have called this ruling a watershed moment in accountability for financial fraud. One prominent legal scholar noted that the judge's language wasn't just unusually harsh, it was deliberately calibrated to send a message to future defendants and their attorneys. When a court describes your arguments as frivolous and unworthy of the court's time, that's not judicial frustration spilling over into the written record. That's a formal signal that you've crossed a line from aggressive advocacy into bad faith litigation. Several appellate attorneys with decades of experience practicing in New York courts made a critical observation. Appellate judges typically bend over backwards to avoid language that could be interpreted as prejudging issues or demonstrating bias. The fact that this judge departed from that norm so dramatically suggests the court believed Trump's legal team was deliberately misrepresenting established legal standards and wasting limited judicial resources with arguments they knew had no legitimate basis. Constitutional law scholars have been particularly focused on analyzing the due process arguments. One Columbia Law School professor published a detailed analysis noting that Trump's constitutional claims fundamentally misunderstand what due process protections actually guarantee. Due process ensures you get fair treatment before a judgment is entered, not immunity from enforcement after you lose. For decades, a common strategy among ultra-wealthy defendants has been delay, delay, delay. File every possible motion. Appeal every adverse ruling. Use every procedural mechanism available to drag cases out for years. This ruling sends a fundamentally different message. It says the courts are losing patience with that playbook. Looking ahead, in the immediate future, we're talking days and weeks, the Attorney General's office will begin the formal asset seizure process. That means filing official notices of judgment lines with county clerks across New York. It means identifying specific properties targeted for seizure. It potentially means seeking court orders for turnover of assets. This process can move with shocking speed once the legal mechanisms are triggered. Properties can be placed under court-appointed receivership within weeks, meaning someone appointed by the court takes control completely away from Trump and his organization. Trump's legal team will almost certainly file additional emergency appeals, attempting to reach higher courts or find a different appellate judge willing to intervene. But here's the brutal reality they're facing. Appellate judges communicate with each other. They read each other's rulings. When one respected appellate judge has already called your arguments frivolous in a written opinion, other judges are going to approach your emergency requests with deep skepticism. Looking out 6 to 12 months, if Trump cannot secure a bond or successfully overturn the underlying judgment on appeal, we're likely to witness actual property sales. The Attorney General will move to auction major assets to the highest bidders. Who buys Trump Tower? What happens to the Trump name on the building? How do existing tenants react? These aren't hypothetical questions. These are practical realities that Trump Organization executives are almost certainly wargaming right now in private strategy sessions. Trump has spent decades building a global brand. Properties, licensing deals, management contracts, and business partnerships spanning dozens of countries. When foreign business partners watch U.S. courts seize his American assets because surety companies wouldn't back him after a fraud conviction, what message does that send? We're already seeing quiet reports of international partners distancing themselves from Trump Organization deals, renegotiating agreements, or simply choosing not to renew contracts when they expire. This isn't political. This is business. The long-term damage to Trump's international business prospects may ultimately exceed even the $454 million judgment itself. Let's bring this all together with the three most essential points you need to understand. First, the court system has conclusively rejected every legal argument Trump's team advanced to stop enforcement, using language that signals complete loss of judicial patience with delay tactics. This isn't a temporary setback. This is a structural collapse of his legal defense strategy. Second, more than 30 financial institutions independently refused to back Trump's assets with a surety bond after conducting their own professional risk assessments. This represents a market verdict on his financial credibility that no legal argument or public relations campaign can overcome. Third, the asset seizure process isn't theoretical anymore. It has already begun. Real properties representing real business value are now at immediate risk of being seized to satisfy a judgment that courts view as legitimate and enforceable. The fundamental takeaway. When the legal system and the financial market both reach the same negative conclusion simultaneously, wealth and power stop functioning as shields. What matters is whether the law was broken, whether the judgment is valid, and whether you can satisfy it. This moment forces us to confront an uncomfortable question. Is this justice finally operating the way it's supposed to, applying equally regardless of wealth and status? Or does this set a precedent that could be weaponized in ways that should concern us? I want to hear your perspective. Drop your answer in the comments, because this conversation extends far beyond one individual's legal troubles. It's about the fundamental question of whether we still have equal justice under law. If you want analysis that goes deeper than surface-level coverage, subscribe and hit the notification bell. The rule of law only functions when we all understand how it actually operates in practice. Thanks for watching. I'll see you in the next one.